Hi, everybody. This is Judge Jerry Semino in Harris County Probate Court number 1. I want to talk to you a little bit about the 1-minute prove-up for the probate of wills docket, what it is and how to become eligible for it, and why it might be a good fit for you and your clients. Now, I created a PowerPoint presentation to help walk us through, so I'm going to show that now. Before we go into the eligibility requirements, let's talk about a little bit of background. As you all know, back in 2014, the Supreme Court of Texas adopted the new Rule 21F that required the electronic filing of all pleadings. And then when I took office in 2019, 5 years later, even though the district courts were all 100% digital, in other words, even the judges were signing orders electronically, and there's no paper that was needed in that time, the probate courts and the county courts at law were still printing out paper documents that needed the judge's signature. The judge would manually sign, and then they would rescan those documents and submit them to the clerk and recycle the paper. Now, as you know, people were coming to court as well with paper orders, paper proofs of death, paper oaths, all those things, and they were being signed in court either by the judge or by the witness if it's a witness statement, and accepted by the clerk, who would then scan those and then put all that paper in the recycle bin. Now, that seemed to be a little bit wasteful, to say the least, but it was also inefficient, considering the ability that the courts had to handle everything completely electronically. And so in March of 2019, I, and along with some really incredible people here on my staff, began the first phase of digital filing and signing of all documents in Harris County Probate Court 1. But until I could get that done, I also created what was called the Rocket Docket. And some of you remember the Rocket Docket. The Rocket Docket was based on what I had experienced in another judge's court many years ago in Bexar County, where people would bring in their orders. They would have those, the staff attorneys or the clerks would review everything, the orders, the witness statements, proof of death and other facts, for example, and the oath. And if everything looked like it was in order, you'd go up to the judge, and the judge would ask you just a few extra questions and then sign off, and you would go. So it was kind of fast. And it was more efficient. And so what I asked is that people email all of those documents that would normally be signed in court later on during the hearing, email those documents ahead of time to the staff attorney, who would review everything. And if everything was in order, then at the day of the hearing, the attorney only had to ask a few questions, 4 questions of their client, and move to the clerk's position and sign everything there, because it would all be ready. That moved things along quite quickly, and we were able to clear out our dockets very fast and offer hearings to people in a very short amount of time. So then we moved into the digital age. And so by June of 2019, we completed the final phase rather of digital documents. In other words, by June, which was way ahead of schedule, Probate Court 1 was had already stopped printing all documents that needed the judge's signature. And I was signing everything electronically, but also, if you'll see the picture here, we had electronic signing by your clients, or whoever the proponent of the will was, perhaps the attorney, of the proof of death and other facts, and the oath was all signed electronically. So there was no need to bring any paper to the court, because you were asked to e-file all of that ahead of time rather than email it. So in July, since by June everything was working great, by July we created a new administrative order 2019-1, which encouraged everyone in Probate Court 1 to electronically file all of their documents, their proof of death and other facts, as a proposed order. Their proposed order as a quote proposed order, so that we could review them ahead of time, and you would at that point be allowed to go on to the Rocket Docket, which was a special docket just for the quick prove up of these documents. And so by January, there was really no need for a special Rocket docket because we weren't emailing documents in. Everything was being e-filed. And so we moved from having a specialized Rocket docket to doing a 1-minute prove up on every probate of wills docket. And the way that happens is you e-file everything, it gets approved by the staff attorney, and then the staff attorney notifies you automatically that you're eligible for the 1-minute prove up. And it's up to you if you want to use the 1-minute prove up or if you'd rather do the traditional prove up. That's entirely up to you. But people who are eligible for the 1-minute prove up get to go first on the docket, mainly because it is so fast and we can clear out those folks. So how do you qualify for the 1-minute prove up? Well, there are some preliminary requirements. First of all, let's see here. There we go. You need to have an original will or original codicils that are self-proven, already self-proven, and whether or not it's self-proven is a matter of law. That's what the court gets to determine, but all of you know how to do that. It needs to be an independent administration or an immuniment of title. In other words, the will has to appoint an independent executor, or you're just probating it as a muniment of title, and you have to have citation and posting completed. And the will and the codicils must already be on file with the clerk. And the reason for that is that we have to not only review the will, not just online, but we have to bring the actual document to the staff attorney so she can review it and make sure that it is an original document, number one, and number two, that it comports with all the rules that make it a valid will. Now, 7 days prior to the hearing, you should e-file at least 7 days prior to the hearing. You should file the proposed order, the proof of death and other facts, and the oath. And you'd file all of these as a proposed order and as a lead document. So that's already a requirement in the administrative order, and it helps us to move things along if you can get those e-filed quickly. Now, here's with your interaction with the court. Now, the court automatically, like I said before, reviews for the 1-minute prove up eligibility. However, you can also ask for a 1-minute prove up by just simply emailing the staff attorney, who is Tamika Harris, and she will help you get set for the 1-minute prove up. The court will also advise you if your case is eligible and then provide you with a sample of 4 to 5 questions that you may want to ask during the hearing. Now, that on the day of the hearing, like I said before, the 1-minute prove-ups are taken first on the docket. The witness will be sworn in, and here are some sample questions. State your name and relationship to the decedent. Now, the relationship to the decedent is not a legal requirement, but it really does help the judge to put in perspective who we're talking to. It could be the spouse or a son or daughter or even a parent. And so the court would like to recognize that relationship and offer condolences in most cases. Identify the document. This when you show the will. If you're in court in person, the judge will hand the will to the attorney. If we're on Zoom, the judge will show the will on the screen. So you identify the document. Do you recognize this as the last will and testament, first, second, third codicil, et cetera, et cetera, et cetera? And then confirmation that testimony has been reduced to writing and that it is true and correct. You testify to that. I will have read it already. And so that's how we kind of get that long testimony, the proof of death and other facts. That's how we don't have to ask all those questions, because you testify at that everything in that document is true and correct, even though it has not been yet executed. Then you just ask the court, what do you want to do? We ask that you appoint this person as independent executor and independent administrator, whatever you're asking for, to serve without bond and waive appraisers. But please, please don't do a 1-minute prove up if you have not been pre-approved. You can't do a 1-minute prove up on a will that's not producible in court, because hopefully you're going to have witnesses there who will testify as to the handwriting of the decedent and other matters, and that will take up a lot of time. So don't try to do that. And if we have not had time to review everything, in other words, I haven't reviewed the proof of death and other facts, when you come up to probate that will, you can't say, it would not be helpful to me to say, we've already filed the proof of death and other facts, and we say that they're true and correct. If I haven't reviewed it, and sometimes those are incorrect because they don't say things like the appointee, the person named as independent executor, is qualified and not disqualified. Often that's left out for some reason. I don't know why, but those are important things to tell the court. So don't do a 1 minute prove up if you haven't been pre-approved. Please do the traditional prove up. All right, so Zoom hearings. This is about how we do it, and this is pretty much where I do mine, from my living room or my dining table rather, or sometimes from my office in my home. We're going to send you a Zoom link. You're responsible for sending the link to your clients and witnesses. Make sure you do that. You can use the same 1 minute prove up that you would otherwise in court in person. I'll show you the will on the screen, and then you ask me or the associate judge here, Ruth Ann Stiles, to take judicial notice that the document in the clerk's file is an original document. That's important. And sometimes that question is left out, and I'll just sua sponte take judicial notice that it's an original, because we will have actually reviewed the original will. We have a staff person here who takes the wills and reviews them in court when I think it's 1 day a week. Otherwise, almost everybody in court, the court staff, are working from home. So at the conclusion of the Zoom hearing, that's when you execute and file the proof of death and other facts. Do not execute the proof of death and other facts until the hearing is concluded, because the statute says that this is your testimony that has been reduced to writing. So you have to give your testimony first and then reduce it to writing. So execute and file that proof of death and other facts. Wait for notice from the clerk that the order has been signed before you execute and file the oath. Now, you're going to know that I'm going to, you'll know when I render judgment on the bench as to whether or not I'm going to admit the will and appoint the named person as the personal representative, the independent executor. But if you file the oath before the clerk has processed the order, then the oath will be rejected. And that's just a technicality. It's not that it's bad or wrong, it's just that it came in the wrong order. So wait until you get confirmation that the order has been signed. Confirmation will be by the clerk, and then you sign the oath and file that. All right, so that's the 1 minute prove up. Good luck, everybody. It's a great thing for clients who have anxiety about testifying, especially if you're here in person. And it's also for attorneys who have other things that they need to get onto and can't really spend a lot of time on this. If you have any questions, you can email my staff attorney, Tamika Harris, at the email address here, which is also on our website, probatecourt1.harriscountykexas.gov. It's abbreviated, but you can find it there. All right, I hope that's helpful. Thank you very much, and I will be seeing you soon.